afternoon. My name is Joe Whitcomb, president and founder of Whitcomb Slinsky PC, located in Denver, Colorado. I am also the author of this new video blog called Vet Biz Law, where we hope to cover legal issues that are important to veteran business owners. And we'll cover other issues, but we're doing it all under the heading of Vet Biz Law. Today I would like to talk to you about what is commonly referred to as the rule of two and the statute and case law that is important to that rule of two issue, specifically as it relates to veteran business owners, service-disabled veteran business owners, and the universe of government contracting. The rule of two, put most simply means this. The government has to first satisfy the rule of two before it can, quote unquote, set aside a contract for a particular socioeconomic group. The policy reason behind that is, or the idea behind that is, if there's at least two companies competing for a contract, then there is, within that, by extension, there is competition, and the government has some assurance that they will receive reasonable pricing for the goods or services that they are attempting to purchase. In 2006, Congress passed a law that is regularly referred to as the Veterans Health and Welfare Act, or also sometimes referred as Veterans First contracting statute. And in that statute, which is under 38 USCA 8127, subparagraph D, the Congress ruled that when a contracting officer has a reasonable expectation of getting at least two offers from service-disabled veteran-owned small businesses or veteran-owned small businesses, and a reasonable expectation that the contracting officer will be able to make an award at a fair and reasonable price, then the contracting officer is supposed to set aside and award those contracts to veteran-owned small businesses. Now, the law was passed in 2006, and from 2006 to 2016, the VA, at least in our estimation, resisted the mandate of awarding these contracts to veteran-owned small businesses. For about those 10 years, for most of the 10 years, the VA took two positions. One, the rule of two in 8127, 38 USC 8127 did not apply to GSA schedule contracts, so federal supply schedules or GSA schedule goods or services. So therefore, if you were bidding for or winning contracts on a federal supply schedule, then you did not get the benefit of the rule of two. And the case law, both from the Court of Federal Claims and the Government Accountability Office, agreed with the VA's position for most of those 10 years. Then in around 2011, a company called Kingdomware Technologies began protesting contracts or solicitations that were not set aside for veteran-owned small businesses. And they had no shortage of victories at the Government Accountability Office. In fact, there's a report that the GAO published in, I think, 2014, in which it instructed Congress that it had sustained about 14 protests on Kingdomware's behalf as related to set-aside issues. In one of those instances, the Veterans Administration simply and put bluntly thumbed its nose at the GAO decision, the Government Accountability Office's recommendation that the contract be set aside for veteran-owned small businesses, and Kingdomware took the case to the Court of Federal Claims. Judge Firestone at the Court of Federal Claims agreed with the Veterans Administration that the rule of two in 8127 was aspirational, and so long as the Veterans Administration was meeting its 3% set-aside goals, then the VA did not need to do more. There was no requirement that it set aside these contracts or award contracts to veteran-owned small businesses. Of course, Kingdomware Technologies took the case up to the Court of Appeals for the Federal Circuit, and the Court of Appeals Federal Circuit, or CAFC for short, agreed with the lower court and affirmed the lower court's decision. So Kingdomware took that case to the U.S. Supreme Court, where it sat, where it took about 2 years to get through the U.S. Supreme Court, and was finally decided in June of 2016. In a rare 9-0 decision authored by Justice Thomas, the Supreme Court ruled, as it had many other instances, that, put simply, shall means must. So the statute reads that the contracting officer shall award. The Justice Thomas, in his written decision, pointed to the fact that the statute in question contained both the words may and shall, and where may and shall exist in the same statute, that the court would take the position that shall meant must. So moving forward from that, the rule was, and has been since 2016, that the VA was required to set aside contracts and award contracts to veteran-owned small businesses, so long as that the contracting officer had a reasonable expectation, which is accomplished by way of market research. So the way this is supposed to work is the contracting officer receives a requirement from one of the contracting officer's customers, a VA employee. They need, widgets, or they need a service, and the contracting officer is supposed to go out into the market and determine, by way of sources sought, or RFIs, or emails, or phone calls, or any other public medium that the VA wants to use, that the contracting officer wants to use, to determine whether or not that contracting officer can reasonably expect at least 2 offers to come in from veteran-owned small businesses. The second thing the contracting officer is supposed to accomplish is a reasonable assurance that the contracting officer will be able to make an award at a fair and reasonable price that offers, in quotes, the best value to the United States. Now, the VA, since 2016, has latched on to that language, and in our opinion here at this law firm at Whitcomb-Slinsky, our opinion is that the VA has held on or latched onto that language in its attempt to maintain its discretion in what it pays for goods and services. The way our law firm interprets that statute is that if the VA rejects a price as being not fair and reasonable, then the contracting officer is saying, by extension, that the government cannot award to that contractor. The pricing is too outrageous. The VA has not been taking that position. It has been taking the position, and has been doing so in earnest for at least the last 2 years, that it is the sole arbiter of what is fair and reasonable. The contracting officer has the sole discretion to determine what's fair and reasonable based on whatever metric that contracting officer is able to come up with. Now, what the contracting officers have done, in our experience, is look at the pricing that the contracting office has paid historically for a good or service. Some cases that we have at the Court of Federal Claims now that we're getting ready to take up on appeal to the U.S. Court of Appeals to the Federal Circuit involve a document destruction company whose historical pricing submitted to the Veterans Administration is far below its GSA approved pricing, and the VA the Veterans Administration contracting officer has rejected those prices as being not fair and reasonable because the contracting officer created what it calls an IGCE, or Independent Government Cost Estimate, based on historical invoices, aka prices that were created more than 5 or more years ago, normally by large companies, sometimes multinational, publicly traded companies, that are far below what a small business is able to do, because a small business and the veteran-owned small business lacks the economies of scale to be able to compete with large multinational corporations in price. So the VA will receive prices from veteran-owned contractors, and those prices will exceed those historical pricing by some margin, sometimes 100% higher, sometimes more, and the VA will reject those prices as not being fair and reasonable. Notwithstanding that fact, the contracts that we've been protesting through this office, the pricing in those submissions or in those proposals were well below that contractor's GSA-approved pricing, and in our view of the world are therefore inherently fair and reasonable. Of course, the courts have not agreed with us thus far on this. We fully expect that we will have to take these cases up to the Court of Appeals for the Federal Circuit, and we expect that the Court of Appeals, CAFC, the Court of Appeals Federal Circuit, will uphold the district court's decisions. And we will then have to seek a writ certiorari from the Supreme Court. Now, we have affectionately dubbed these cases. There's 4 cases right now that we have primed for the Court of Appeals for the Federal Circuit from 4 different angles and slightly different fact patterns. And we've dubbed those cases Kingdomware 2 because we believe that's the one space, these hanging chads, if you will, that the Supreme Court has left open as it relates to the question of what is fair and reasonable, or what discretion does the contracting officer have in determining what is a fair and reasonable price that offers best value to the government. And our argument is the VA should not be in the business of frustrating Congress's intent, which was to award as many contracts as the VA could reasonably award to businesses owned and controlled by veterans or service-disabled veterans. There'll be a lot more on that to come. Some other overlapping issues have to do with issues like limitations in subcontracting, which we will be speaking on in future podcasts and in future video blogs. So we hope you've had, we hope you've learned something from this video blog. We hope the content has been somewhat informative. Of course, if you have any further questions, you're on our website, so you know how to reach us. There's a contact us page. There's phone numbers everywhere. You can reach out to me directly or by email through our website. So, and there'll be a lot more content to come. We will be talking on issues like limitations in subcontracting, what technical acceptability of a contract, evaluation criteria, and a lot of other subjects. But more on that to come. We'll also be doing some interviews in the near term with different members of the law firm in our practice areas. And we'll also hopefully be able to do some interviews with with members of the community here in Denver, Colorado, and in surrounding areas about how the law applies to their businesses and some other things. So again, if you've enjoyed the content, if you found it useful, I hope you'll subscribe to either the podcast or the video blog or both, and I hope you'll tune in later for more content. Again, this is Joe Whitcomb with Whitcomb Selinsky, and I appreciate the time that you have donated, or rather dedicated, to listening to this. Thank you and have a great day.